Impossibility in an Illinois divorce. When someone says their former spouse was impossible, they might argue that fulfilling divorce orders truly is impossible. Illinois courts hear claims of impossibility when one spouse says they cannot comply with a divorce judgment. Most final divorce judgments in Illinois are agreements between spouses and are enforced like contracts. Under 750 ILCS 5500 seconds, e. the terms of a marital settlement agreement have all remedies available for enforcing a judgment and are enforceable as contract terms. Because these agreements are contracts, a party might use contract law doctrines to avoid obligations. A Chicago law firm can help you understand and respond to these defenses. One such doctrine is the impossibility of performance, which allows a party to be released from a contract when uncontrollable circumstances make performance truly impossible. In Illinois, impossibility is only recognized when performance is objectively impossible because the subject matter is destroyed or by operation of law. Impossibility is an affirmative defense to a breach of contract claim and is narrowly applied to extreme situations because contract law allocates risks. The party claiming this defense bears the burden of proving impossibility. For example, if marital property was destroyed by a fire or flood, transferring that property as promised could be impossible. The doctrine has potential for abuse if a spouse causes circumstances that prevent performance, such as letting a dog run away and then claiming delivery is impossible. Illinois courts do not accept impossibility when circumstances were foreseeable at the time of contracting. The party must show that the events rendering performance impossible were not reasonably foreseeable at the time of the agreement. A contingency that causes impossibility must have been anticipated and provided for in the contract, or else impossibility is unavailable. A party cannot claim impossibility if they created the situation or failed to try practical alternatives. Courts look for whether the claimant contributed to the circumstances and whether practical alternatives exist to permit performance. In Ulanoff v. Ulanoff, the husband's health was so poor that obtaining life insurance as agreed was impossible, and the court ordered him to deposit $250,000 into a joint account instead. The impossibility doctrine mainly applies to property division clauses in a divorce because property rights become vested and cannot be modified. When a property clause cannot be modified, performance can only be excused by a valid defense like impossibility. Other aspects of a divorce, such as maintenance, child support, and parenting arrangements, can be modified with a substantial change in circumstances. Maintenance and child support may be modified or terminated upon a substantial change in circumstances. Parenting plans and allocation judgments may be modified when a substantial change arises and modification serves the child's best interests. Because most duties can be modified, the impossibility defense is rarely needed and courts prefer to find practical alternatives. A claim of impossibility may fail if there is an alternative way to perform the obligation or to compensate the other party. Illinois judges will scrutinize the facts to determine whether impossibility truly prevents performance or whether the party is avoiding responsibilities. Using contract law to avoid fulfilling divorce obligations is risky, and courts expect spouses to anticipate and allocate foreseeable risks. If an ex-spouse claims impossibility, consult a divorce lawyer who can evaluate whether the defense has merit. A knowledgeable lawyer can help you gather evidence to show whether circumstances were unforeseeable and outside the party's control. Do not assume that retirement or career changes make your obligations impossible, because such changes might have been foreseeable. Courts may require alternative solutions, such as the deposit ordered in the Ulanoff case, rather than excusing performance entirely. Almost nothing is truly impossible when you work with a dedicated attorney to find solutions. To understand your rights and obligations after divorce, speak with a family law attorney in Chicago who knows Illinois law. The law office of Russell D. Knight is a Chicago law firm that can help you determine whether an impossibility defense applies and guide you through post-decree disputes. Contact the law office of Russell D. Knight at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States, at 773-334-6311.